morning. Please be seated. We're here for oral argument on Contreras versus Bourke. It's our number CV-24-0217. A couple things before we get started. First of all, this is a momentous occasion for us because it is the first time we've had a complete court with Justice Mary Elena Cruz joining us. This is her first oral argument with us, so we'll always remember this case, so don't mess it up, Don't mess the argument. Second, each side has 20 minutes, and there is a clock at the podium for your use, and you may keep whichever time you'd like for rebuttal, but you'll have to keep your time yourself on that. So with that, let's begin. So please begin.
Just for announcement, obviously, I believe that Ms. Bourke is going first.
Nope. It is, whose petition for review is it? It's Ms. Bourke's. Oh, well, you guys, okay, we're all ready. You're on the wrong side. You're messing us up already. But thank you. That's why I'm looking to you going, okay. So please, well then, Miss, is it Bourke or Bourke?
It's Bourke. It just looks like
Bourke. Okay, either one. Ms. Bourke, please begin then, and we'll just keep it, and you've got that right of who to keep. So you'll have to keep whichever time you'd like for rebuttal.
Thank you. Good morning, may it please the court. Nancy Bourke here, pro se, not by choice, by necessity. So the answer to the court's question that I granted on my petition for cross review is yes. A judge is disqualified after self-recusal in a dissolution action. And the reasons for that weren't quite easy for me to articulate because I don't know that this has been decided before. So, and I think that's also because the statute is somewhat new in Arizona for vexatious litigants, and I don't think this particular question has been addressed. I couldn't find any precedent anywhere, let alone in Arizona.
Ms. Bourke, may I ask you a couple actual questions?
Sure.
So that I have this straight.
Absolutely.
From what I saw, you knew at some point, while this was still at the trial court level, that the judge, Dickinson, had previously recused himself in this case.
Correct.
Is that correct?
Yes.
Did you know, or does the record reflect at least, that you had knowledge that he had appointed Mr. Contreras as a JP while the matter was pending at the trial court?
I did not know that. It turns out that it was about 35 days after the motion to designate me vexatious was renewed for something like the third time. I had been through that motion before several times. And as Mr. Contreras pointed out in his, I think it was the third motion that we're here on today, to designate me vexatious, he mentioned himself that prior versions of his motion to designate me vexatious were delayed because of self-recusals. And one of those, in the time frame that Mr. Contreras mentioned, was Judge Dickerson's actual recusal from the dissolution action as a trial judge.
And did, at the point in time that you learned that Judge Dickerson had appointed Mr. Contreras as a JP, was there an opportunity under the family court rules to move for relief from judgment from that vexatious litigant order to say, hey, wait a minute, I think you have a conflict here, and I want relief from that order because of it?
I can't recall the timelines in the rules offhand, but when I first realized that he had appointed him, it was, I believe, the week that my opening brief was due to Division II Court of Appeals.
Okay, so you'd already filed your notice of appeal by then?
It was long past then, yes.
Okay, thanks.
Yes. And so, and in a dissolution action in particular, I think it's important that the court clarifies that self-recusals will hold when it comes to a vexatious litigant statute, because the vexatious litigant statute is it's one of those statutes that the legislature appears to have enacted with a lot of strong language, and it's, by definition, unilateral. So in order for the proper findings to be made, all of the statutory findings to be made, the court has to go through one side only and make judgments about their conduct, which in a dissolution action, that's the 403A1 factor. It's a very important factor going throughout a dissolution case. So when a judge recuses in a dissolution case and does not give reasons, which they normally don't do, in fact, I see this court all the time.
Does the record here reflect why Judge Dickerson recused in the first place?
No, it does not. And that is something that I had relied upon particularly because, unfortunately, I've had 2 divorces, and both of them were in Cochise County. And shortly before this version, after this particular version of the vexatious litigant motion was filed, I had filed for my second divorce out of Cochise County as well. And the cases, in terms of the self-recusals, were similar in that in Mr. Contreras' case, all the judges recused almost immediately, were both practicing attorneys. I didn't ask why, it just happened, and I expected it. However, with my second divorce, everyone had self-recused except for Judge Dickerson, actually. So when he did not recuse in that second case, I had just gone with it. He made substantive rulings as the trial judge there and became presiding judge soon after. It never affected that case in terms of him being the presiding judge, but I went with that. However, in this case, he had self-recused as the trial judge, and I wondered what the differences were in my mind, which I don't think is terribly relevant in a case like this, actually. I think that's why the answer to the question the court asked is yes.
Okay, so let me
Yes,
stop you there.
sure.
If the answer to the question is yes, tell me under Rule 211A, A1, or just Rule 211, why? Why is the answer yes?
Well, 211A speaks specifically to the judge knowing personal facts. And I think in a case of self-recusal, when the reason isn't given, which my understanding is that's normally what happens, the reason isn't given, the self-recusal just happens. And the parties are not given the opportunity to ask. And it's somewhat circular, but in my mind, I figured Judge Dickerson, especially given that I had 2 cases, he knew the facts as to why he was self-recusing. He didn't give us the opportunity to object or agree. He just did that and moved on with one case and not the other. So, the personal facts are in his mind, and it's not, frankly, a party's business to question why a judge would recuse. And I didn't feel it was my business to ask him to recuse again. He had already done so.
Counsel, let me ask a question then. So I want to make sure I understand you in relying on the personal facts part of 211A1. Is that because you didn't see any bias or prejudice against you in the second case, that you're deducing the basis for his recusal in the first one then must have been based on personal facts?
Oh, actually, well, I didn't think that much about it, frankly. I had to sort of look back on it and see why he didn't recuse again, I suppose. And it's not necessarily the personal facts. I mean, in my mind, which I do think is kind of irrelevant, I thought it was more that there was a bias in favor of Mr. Contreras rather than against me, because I was the same party in both cases. And it's not just the personal facts, because again, I didn't find it my place to look into his mind. I mean, attorneys are told from the start, you can't just go into a judge's mind. Please don't go there. And I don't want to go there. I relied on the recusal in the one case versus the other. And I think the answer to the question is yes, because of the personal facts issue, but also because he showed that he was already going to be perceived as biased. And I think that's one of the bigger issues as well, is the perception at large. I mean, there's, the procedural issue in my particular case. I think there's a sort of political type issue as far as perception of the public. And there's other issues as well, but I think those are the two. I can't determine what his personal facts are that he believes he knows.
Go ahead.
In your view,
Yep.
once a judge self-recuses, doesn't provide an explanation or a basis for the recusal, can that judge ever return to preside over that matter?
Preside over that matter?
That case, return to the case.
I think if there were reasons given in the first place and those reasons had resolved, certainly, and there's plenty of case law, and I think I cited some of it, where they can certainly return for ministerial matters or administrative matters, but the vexatious litigant statute goes well beyond that. You have to consider conduct of only one party. And in this case, and probably most of them, I imagine that it's on the motion of the other party. So I think they can, and people can even agree to have a biased judge, whatever that term may mean, come back on. But that didn't happen here.
But it would require some explanation by the judge to the parties, consistent with Rule 211, Comment 5.
I think it would either require that or it would have to be an administrative or ministerial act, not something substantive.
What do we do, though? I certainly think the judge should have said, hey, I've recused on this case, but this is why I'm coming back, to
Sure.
give the parties that opportunity.
Sure.
But if that's so, if the judge made a mistake here, I'm trying to think, what's the remedy? I am a little concerned that you didn't raise it to the court to make a record to assess whether there's actual bias here, or was it just an appearance of impropriety or appearance of bias? Because sometimes judges will recuse just for that reason. In fact, I think most often it's more of an appearance than an actual bias.
Right.
So in terms of assessing, did it make a difference? Were you harmed? That kind of thing. It's difficult when we don't have a record. And so could you address that? I mean, have you waived your issue by not raising it to the court so the court could make a record of what went on?
Right. So I think that the majority in Division 2 thinks that I did waive it. And the dissenting opinion points out the fact that I did actually talk about the judge recusing himself. And I didn't go into specifics because I knew that he didn't give a reason in the first place. And I don't feel that it's my business, however the court would like to put that in more technical legal terms. It's not my business or even my burden to have gone backwards in time into the judge's mind as to why he self-recused or why he would even consider coming back on. And at the time when I raised this in the motion practice at the trial court level, I simply stated it as a fact. I felt that Mr. Contreras was judge shopping. I did not know that he had just been appointed by this judge as a pro tem judge for the first time. I didn't actually know that. But I put in the motion practice that I felt that he was looking for someone else to address the substance of the dissolution matter, because he had just been denied some motions in that court within less than a week prior to filing his motion again, to have me designated again. I frankly thought at the time that raising the issue would be it, and perhaps Judge Dickerson was doing the preliminary matters of getting the motion response and reply in, and then he was going to reassign it. Before I knew it, he had ruled, and I did not come out and say, please recuse yourself. I didn't. And I didn't think it was my burden to do that. I figured the judge.
Counsel, pardon,
Yes.
let me ask you a question about that, because you mentioned several times you didn't feel as if that was something you could have done. And I'm curious whether or not you're basing that on a particular ethical rule of professional responsibility, or this court's prior case law, or some ethical advisory opinion, or is this just a matter of practice and custom?
That I couldn't have asked him to recuse?
That you didn't feel like you could inquire into why he had recused in the first place, to then have a conversation on the record about the status of things in the current case?
Frankly, at the time, I didn't think he was going to go all the way through with deciding the actual substance of the motion, given what it was asking, what the statute says, what the vexatious litigant statute says, and the fact that he had been asked to address it only in terms of the dissolution. I didn't think it was...
So I understand that.
Sure,
I understand why the timing-wise, but I'm really curious, because I want to know if this is something we might have to clarify.
Right.
Why you felt that you couldn't bring that issue up before the court.
At the time, it wasn't a conscious decision to not, to think to myself, I cannot do that. I thought he was doing the administrative part of getting the motions in and probably reassigning in the background. And there are, I forget which case it was that I pointed out to the court, but it's been pointed out over and over again, if you don't want to, if you are thinking about alleging bias, but the judge had already self-recused, it's going to be problematic where you're going to have to make allegations based on speculation and facts. You're going to taint the case for that judge and any future judges. I just didn't think to sort of guess that he was going to not only proceed, but yes.
You knew that this decision might be made by Judge Dickerson. You knew that was on the table when you said that father wishes for the presiding judge, who already recused himself due to conflict of interest, to address the merits of the motion. So you knew that was in play. Why would you not object to express and to preserve the fact that you did not want this judge to sit on the determination of whether or not you were a vexatious litigant? Why not preserve the objection?
Sure. Well, I didn't think I had to, because he had already self-recused. He had already shown that appearance of impropriety. So you assumed he would not hear the vexatious litigant motion? I don't know if I would go back in time and allege that there were assumptions made. I'm not sure if I could say that things have been very crazy, for lack of a better term. So I'm not sure at that time if I consciously thought about that. But I know that if I were to have raised bias myself, rather than just relying on the judge's self-recusal, it would have raised all kinds of other issues for me in a small community.
So then you concede that this statement you made was not an objection?
I don't know if I would go so far as to say that. Yeah, I mean, it wasn't a 409, certainly. It wasn't an affidavit alleging bias. I sort of wrote that in passing because he had already done that work of showing that he's not appropriate to decide this case a year and a half or so prior. So I don't think, I didn't think that I had to go out of my way to try to prove something, especially when he self-recused without giving that reason at that time.
Now, the actual family court case is treated separately, distinctly from the vexatious litigant motion, isn't that right?
In this case, it was not. Father had asked that I be designated vexatious solely within the context of the family law case.
Right, but the determination of whether or not a person is a vexatious litigant is made by the presiding.
Or his designee, correct.
Right, so it's treated separately from the actual family case.
In this case, it was not. And that's shown throughout the ruling itself, the 5-page ruling or so. This court, this presiding judge talked about going back an indeterminate amount of time to review the trial court's rulings over and over again and rely upon those rulings that were made by judges that did not recuse.
You might want to save the rest, your 30 seconds.
Thank you.
Thank you. Okay, is it Ms. Paul?
Yes. May it please the court. First and foremost, I would like to point out that Ms. Bourke just violated Ethical Rule 3.1. She specifically misstated facts, and it is proven by my response to cross-petition in paragraph 6, where she stated that she had no idea that my client had been appointed to the bench as a judge pro tem prior to Judge Dickerson issuing the ruling. The hyperlink is contained within the brief, and it shows that on January 13th, 2023, long before Judge Dickerson ever made any kind of a ruling or even ordered Ms. Bourke to respond to the petition for vexatious litigant, she was well aware and publicly posting regarding the fact that she had knowledge of and was very distraught that my client had in fact been appointed as a judge pro tem.
Well, let me ask you this, because those are slightly two separate things. I mean, I had asked her if she knew that Judge Dickerson had made the appointment, and you said, well, she was aware that he was a judge or a pro tem justice of the peace. Thank you. They're not necessarily mean that she knew he appointed her or she knew what the process was. Is there anything that shows that?
I believe that in the link that you can see, I believe she specifically stated that it's Judge Dickerson because at that time he was the presiding judge in Cochise County.
So counsel, let me ask you a question about that, because if he's the presiding judge and he's going to appoint Mr. Contreras a pro tem, doesn't that require that he make a finding that Mr. Contreras is of good moral character?
Absolutely.
So he's passing judgment on his character.
That is true.
Okay.
Because we can't appoint
So
it.
why doesn't that raise an issue then for a judge who is on a case with two parties to have specifically commented then on one party's good moral character to sit on that case?
I don't believe that would, I mean, we as attorneys, when we appear in front of judges, obviously, there's hopefully a presumption that we have good moral character.
Well, but there's a difference between that general presumption that parties who appear before a court are going to be honest and ethical as the professional rules require. Don't you think there's something different, though, where a judge is making a particular finding in order to make an appointment like this?
I don't know that there's a distinction.
You don't? I mean, one's a constitutional requirement. The other one is a general presumption made by all parties who appear in front of a court. But a judge doesn't have to put on the record at the beginning of any proceeding, I find these two attorneys appearing before me to be of good moral character.
That is factually accurate, of course.
I try to be.
Yes, wow.
And doesn't that implicate 211A, a judge shall disqualify himself or herself in any proceeding in which a judge's impartiality might reasonably be questioned? To Justice Montgomery's points, the fact that Judge Dickerson appointed your client to be a judge pro tem, JP pro tem, wouldn't that raise flags that that judge's impartiality might reasonably be questioned to be fair when he made those determinations to appoint him to be a judge pro tem?
Ms. Bourke was aware of that, and Ms. Bourke had the opportunity to then request.
That's really not my question. It's not my question.
There's two.
I see the distinction. I see the distinction. I don't believe that would necessarily invoke an idea that his perceptions of my client would supersede the perceptions of Ms. Bourke, especially given the fact that Ms. Bourke has even stated that Judge Dickerson was assigned to her other divorce case and proceeded on that. Ms. Bourke had no issues with him proceeding under those circumstances.
But counsel, that kind of underscores the point. If he can be fair to her, if Judge Dickerson can be fair to her in any other proceeding, but for one involving her and Mr. Contreras, why doesn't that then raise at least the appearance of impropriety that should have required Judge Dickerson to at least put on the record what the basis was so the parties could be made aware of why he recused in the first place?
So at the point in time when Judge Dickerson initially recused himself, which is contained in Record on Appeal 29, there were no reasons given. All he did was recuse, as Ms. Bourke has said. At that point in time, Judge Dickerson was the presiding criminal judge for the county. This occurred, obviously, over 3 years prior to the instant request for the vexatious litigant designation. And I would assert that it's more of a ministerial task. He's not opining on the efficacy or making any substantive rulings in this matter by reviewing the evidence.
But I'm sorry, with respect to what, in the first recusal? Or
No,
when he ruled on the
with
vexatious
regard
litigant
to
motion?
whether or not the conduct that Ms. Bourke engaged in was vexatious.
You don't think that involves this?
Oh, yeah, no. Doesn't that have substantive implications for her abilities to, I mean, it seems to me to be more substantive in nature, to make a determination on a motion for vexatious litigant.
Well, the fact is, even the opinion, the justices or the judges that made the decision on the opinion said that the record supports the conclusion that Ms. Bourke is a vexatious litigant. So the totality of the record in this matter supports the fact that if you take a look at the pleadings that were filed by Ms. Bourke, and the primary reason is obviously she continues to file the exact same motions over and over again.
Well, that very well may be, counsel, but it still begs the question on whether or not an impartial judge sat over the proceeding to make that determination.
But there's nothing in the record to reflect the fact that he was not impartial. So if...
Well, he recused himself, and then there was an administrative order after the recusal saying that there was a conflict. And the record's silent as to what the basis of that conflict was, so it leaves us to kind of wonder about it.
And that's when Ms. Bourke could have requested clarification as to why the recusal occurred. The fact of the matter is that...
Well, I'm curious, why didn't you want to know?
Why didn't I want to know?
Why didn't Mr. Contreras want to know the basis for the recusal? Was it because they figured it broke in his favor, so there was no need to look for it in the second case? I'm speculating now, but I want to know, why is it all on Ms. Bourke? Why don't we know? Because it could be just as much then that the judge recused the first time around because there could have been something with Mr. Contreras.
Well, it could have been, just like you said, Judge. It could have been that he had a bias against my client, not a bias against Ms. Bourke.
So why is it all on her to find out why there might have been a disqualification in the first place?
I don't think, as Ms. Bourke said, trying to get into the mind of a judge as to whether or not, or the reason behind a judge's recusal, I think that it's inappropriate for an attorney to...
Counsel, doesn't the judicial officer have an independent duty to remove himself when his impartiality might reasonably be questioned? So regardless of whether a motion to disqualify is filed, regardless of whether a litigant files an objection, we've talked a lot about waiver and whether Ms. Bourke properly and timely objected, but isn't there an independent duty on the judge to recuse or remain recused in a case?
I believe that the Code of Judicial Ethics is very clear in that there's an automatic presumption that a judge is going to be fair and reasonable under the circumstances, and in the event that they feel that they have a bias, they should recuse.
What about the language in comment 2 to 211A saying, to Justice Cruz's point, a judge's obligation not to hear or decide matters in which disqualification is required applies regardless of whether there's a motion to disqualify. Seems under that comment that a judge almost has a freestanding obligation to decide whether or not they should disqualify themselves in a case, whether a motion was filed or not, prior to hearing the case.
I don't think that obviously there is no compulsory obligation for a judge to recuse under circumstances if they believe that they can proceed and be fair and impartial. And I think that it's really important for us to look at the comments in 211C. And that states that the code is not intended to be the basis for litigants to seek collateral remedies against each other or to obtain tactical advantages in proceedings before a court. Thus, a litigant's lying in wait for an adverse decision to claim judicial bias can never overcome the responsibility to raise the issue before such a decision is rendered. In fact, in the opinion that was issued by D2, it states that Ms. Bourke should not be afforded the opportunity to pocket the mulligan and then raising it as an issue when it got to the appellate court level and for the first time. And
Well, can you expound on that? Because that's something that I'm very interested in, and procedurally how we look at this case. Because I think everyone will think, benefit of hindsight, Judge Dickerson should have said, hey, I'm back on this case, and my recusal, my conflict has disappeared, something to put on the record. But he didn't. And so even assuming that's an error, where we go from here is of concern to me. It wasn't raised, so usually we look at, okay, you've waived it absent fundamental error. Do we conduct a fundamental error review here? Is it something that would rise to the level of structural error, where it doesn't really matter about the prejudice? It's just line in the sand. So could you shed some light on that, of how we should examine these issues, through which lens?
And in preparing for this argument, obviously, this is an issue of first impression. When you look at the vexatious litigant statute and you run it through Westlaw or Lexis, this case is the only case that is actually cited with regard to the vexatious litigant statute. So when we take a look at substance over form, I think that what do we do? Like, how do we proceed, and what remedy should be taken? I wholeheartedly believe that in the event that this is remanded, there's going to be a significant waste of resources.
Well, you're jumping over what I'm actually asking, so I probably didn't ask it very well. I'm really asking, what should our standard of review be here? If Ms. Bourke had objected, that would be easy. We would say, well, did the court abuse its discretion at the trial court level by failing to recuse, or failing to re-sign this to someone else to hear? That would be what we would be looking at. Here, there's been no objection, so normally when that happens, we're looking at, well, was there an error, and if so, was it a fundamental error? But once in a while, something will rise, in a rare case, rise to the level of structural error, such as if you have a biased judge. I think the Ring case, State v. Ring, said biased judge means you didn't really have a neutral arbiter. That's a structural error. So when, as an appellate judge, that's what we're looking for, of like, which lens do we view this through?
So in the event, I suppose, obviously, we are here today because clarification at some level is necessary in order to make sure that this doesn't happen again. And so, moving forward, separate and apart from this case, I suppose that you are going to come up with some guidelines or some instruction to help judges moving forward so that this does not happen yet again. Because obviously, you all believe that this is something that could reoccur in cases in Arizona, not just in family law cases, but potentially in civil cases, et cetera. And so based on that, you're going to have to come up with parameters and potentially instruct a judge that in future cases, should there be a question that there and a judge who had previously recused for an unknown reason, potentially instruct them to state, you know.
Well, we don't entirely have that luxury because we
Right.
have to decide this case.
Right.
And to return to the Chief Justice's question, it seems to me here that regardless of what Ms. Bourke did or didn't do to preserve her rights under Rule 211, it really puts the burden on the judge. Let's take a hypothetical. Suppose, I don't know what type of law Mr. Contreras practices, but suppose the judge was getting a divorce and hired Mr. Contreras as his attorney. Not well known, but a pretty significant relationship. Would he have been required to recuse under an appearance of impropriety?
Absolutely. And I think there's case law that says that, I mean, one of the cases that was cited was because an attorney in a criminal matter had filed a wrongful termination or an employment law action against the judge, and then the judge found the...
Well,
so
how is this really different? The Judge Dickerson hired Contreras to be a pro tem justice of the peace, making those same, types of judgments regarding his character.
So he was not, first of all, he was not hired and not appearing in Superior Court. He was doing initial appearances in Justice Court. So
Right, but it's the process of the act. It's Judge Dickerson's act of selecting and finding that Contreras met the requirements, which include good character.
Right, but we have nothing in the record to presume that he didn't find that Ms. Bourke also didn't have good character. While there is, obviously, by appointing my client as a judge pro tem, he had to make that finding under the Supreme Court rules. There's nothing in the record that reflects the fact that he thought that Ms. Bourke was not also a good
But by
character.
nature, vexatious litigation is aimed at someone. And if it's aimed at a really good guy, that the judge has opined that that this person is a really good guy, isn't that relatively equivalent?
I don't know that I would necessarily draw that conclusion. That he's making statements that would, lend one to believe that he's going to favor my client over Ms. Bourke. I think that the record reflected and supported his ultimate decision. And so,
But that's not the standard under 211. The standard under 211 is appearance of impropriety, appearance of bias. And this is, frankly, less about, from my view, it's less about the litigants and more about public confidence in the judiciary.
And again, I come back to there are so many unknowns. And as
Counsel,
far as
I think too little has been made about the decision that the presiding judge makes as to who to appoint as a justice of the peace. We're talking about a small rural county. I think there are just a handful of Superior Court judges and probably about the same, so about 6 judges. And how many JPs?
that, I don't know.
6 JPs, your client is indicating. And so a presiding judge has to look at the applicants or single applicant and decide whether this person can be trusted to make decisions about release of people, not only in misdemeanors, but in felony matters, serious matters, decisions in civil cases, in all sorts of different cases. And so the presiding judge in a county who is tasked with administering the business of the courts has to in turn choose people who are trustworthy and are not going to harm the public. And I don't think we can minimize that by saying it's sort of some ministerial act. He doesn't know who this person is, just kind of signs him on. Isn't there a good argument to be made that Judge Dickerson made a determination that your client was a person of good moral character to have this position of respect and authority in the county?
I would go back to Zuniga versus Superior Court, and whether everything that we're looking at right now is mere speculation. Without any facts before the court, everything we are looking at is conjecture.
I don't think we're speculating that the presiding judge trusted Mr. Contreras to be of good moral character and to be trusted with the decisions that he would be making in the county. I don't think that's speculation.
No,
he put his signature to that.
That was done, but that there would be a bias in favor of him is what I'm saying is the mere speculation. The fact that he
Counsel,
says...
let me ask you this before your time runs out, and I want to underscore, too, what Justice Bourke said. I think this case is less about the litigants themselves than it is about what we have in a record from the judge here and what he, 2.11 calls for. So to sort of circle back, do we look at this from a fundamental error standpoint, or do you look at this from an abuse of discretion standpoint? How should we review this particular case?
What? Yeah, harmless error is what I would say.
Harmless error, that's not as rigorous as fundamental error.
Right, but the facts and circumstances, the ultimate decision was supported by the record. So that's why on remand there has been significantly more vexatious conduct that Ms. Bourke has engaged in that was outlined in Judge Dickerson's ruling. So if we weigh this moving forward, there's even more evidence at this point. In fact, one of the pleadings was filed in this matter where Ms. Bourke requested that the BIA be removed again, and that's not even an issue that was before the Supreme Court.
So, counsel, if there is so much overwhelming evidence that Ms. Bourke is a vexatious litigant, what is the harm with sending this back to have a separate judicial officer and take a look at the motion and decide on the issue?
Because the history of this case demonstrates that it will then go back up on appeal again. I think that there were 8 appeals pending in less than a 3-year period in this matter. This is probably one of the most highly litigated cases in the history of the state as far as a family law matter goes. The child is 14 years old, and I believe that there have been 13 appeals and special action, well, including special actions that have been filed in this matter. And so the detriment would be the significant increase in expenses and the time that the parties and the judiciary is going to incur by having this remanded, when even the Court of Appeals, the opinion that was issued said that there's sufficient evidence, and having them review it to support the conclusion that Judge Dickerson reached.
And Ms. Hall, you are well beyond your time because we've kept you beyond your time with the questions, but I think we've got one more question, and I'm going to, at least one more, so go ahead and feel free to answer it.
You've noted a number of times, I think accurately reflected in the record, that we don't know the basis for Judge Dickerson's recusal, but we do know that at least the court administrator noted a conflict in the transfer order. Now, I'm not sure that that's terribly helpful for your side, and my question relates to Rule 2.7 of the Code of Judicial Conduct, and it provides that a judge shall hear and decide matters assigned to the judge except when disqualification is required by Rule 211 or other law. Why should we presume, without any explanation for the judge after a self-recusal, when the judge returns to deal with a matter involving one of the litigants in which he has recused him or herself, why should we presume without explanation that whatever the conflict was has now self-resolved? And why isn't that judge required to apprise the parties of what the nature of the conflict and why they should not be concerned about his or her impartiality upon the return after declaring a recusal?
Obviously, prior to this case, that doesn't exist. That wasn't an issue that had previously been pled, litigated, and pursued at the appellate court level. So while the canons of judicial ethics may have that statement, there was nothing, apparently, that Judge Dickerson felt rose to the level that he was not going to be fair and impartial. And so I think that having been on the bench for over 20 years, that Judge Dickerson's judgment as to his ability to be fair and impartial under the circumstances should be given great weight. And I would go back to one of the cases that was cited by Ms. Bourke, and that's Nordstrom via Leonardo. And it talked about the fact that issues like this that are being decided by the presiding judge are administrative. And he's not weighing in on, he's not giving any substantive rulings on the merits of the case and issuing a decision regarding this minor child, because that's all we're fighting out. This entire case has to do with lots of litigation regarding one little boy who turns 15 very soon. And so he's not weighing in on anything regarding legal decision-making, parenting time, child support, any of the issues underlying. He's reflecting and looking at the record, having been on the bench for over 20 years, and making a determination as to whether or not the pleadings that were filed in this manner by Ms. Bourke were vexatious in nature. And in his ruling regarding the fact that designating Ms. Bourke as a vexatious litigant, one of the things that he pointed out was in response to, I believe it was a 7-line position or statement in my petition to my renewed motion to designate her as a vexatious litigant. She spent a page and a half responding and disparaged the court. She constantly makes false allegations regarding domestic violence when she's the only party who the Court of Appeals has stated has been a perpetrator of domestic violence. But this is a narrative that Ms. Bourke constantly sends out.
Okay. Any further questions then? No, thank you. Thank you, Ms. Paul. In fairness, because we really went on and on with that, can you add maybe 3 minutes? So, Ms. Bourke, I'll give you 3 minutes to do any rebuttal.
Thank you. A few times Ms. Paul talked about whether Judge Dickerson believed he could be fair and impartial, or he felt he could be fair and impartial. And that's exactly the crux of the issue here. We don't go there. And the Rule 211 talks about impartiality reasonably being questioned. It's going to be questioned, and I think it was very reasonably questioned here for all the reasons talked about earlier today. And in the vexatious litigant statute, you have to make substantive determinations about parties. It's not a ministerial act. And Ms. Paul, towards the end of the argument here, talked about multiple pleadings being filed by me. The court mentioned 4, and the 4 that the court mentioned was a motion to continue, one regarding being equally treated about a gag order, wanting the proceedings to be public, and other sorry, what was the 4th? To terminate the appointment of the best interest attorney, who I made those arguments before. None of them had been ruled upon. And the court here went into those four in particular, but he sort of just listed them and said they'd been argued before. They hadn't been decided before, except for the motion for equal treatment regarding the gag, which was granted and saved the court a whole lot of time and a whole lot of energy because there were hundreds of pages related to Mr. Contreras' pleading in that regard. We can't go with what the court felt or believed, as Ms. Paul wants us to do, as far as the recusal or lack thereof the second time. The court already pinpointed that he was recused and didn't state what his feelings were or the substance of those feelings, but for the public to be confident, which I agree, I think this is more about public confidence than these particular parties.
Ms. Bourke, can I ask you a quick
Sure.
question for your time's about to run out?
Sure,
Just
sure.
a factual one. Does the record show that you knew that it was Judge Dickerson who appointed Mr. Contreras as the JP while the matters were pending below?
The record does not reflect that, and I can tell you, I did not know that. I don't know the ins and outs of the court procedure. I've never tried to be a judge. I've never applied. I don't care to be one. So I didn't learn about it. I didn't investigate it at the time. I was relying on his recusal before.
Okay. Thank you very
Thank
much.
you.
All right. I thank all counsel for your argument, your briefing in the case. It's a difficult one. I appreciate your professionalism today. And we'll take the matter under advisement and issue a decision in due course. And until then, we stand adjourned.